sure they don't have it on me, you know.
Good morning, Romulus.
Good morning, Your Honor.
Good morning, Your Honor.
Andy's on her way back downstairs. As soon as Mr. Jadala logs on, we'll get you connected.
Wonderful, thank you.
You're welcome.
I know. He didn't. All my other babies, he been my life. It's been a long time, man, so I got in trouble. That counts?
Yeah, man, everything counts. You just gotta. You'll talk to him. He'll explain everything. He'll square you away.
Good morning, Mr. Beers.
Good morning.
Mr. Beers, you're here for Mr. Best, or in place of
Yes,
Mr.
we're
Best.
both, yep, both in the same office.
Okay, thank you. Jeffrey Beers.
And I've got two. Another one at 9:15.
Okay, thank you.
Thank you.
Hi, on Renee's iPhone, what's your last name, please?
Walker.
All right. Mr. Beers, did you want to speak to Miss Walker?
We can, yes.
All right, let me just rename you real quick. Hi, Andrew, what case are you here on, please?
Case number 23-01446.
Let me check that. That looks like it, a dismissal with prejudice went out on February 1st.
Okay, because I got the summons for the court, and then like 3 or 4 days later, I got from the place that I paid them off.
Okay,
I never
yep.
got anything that said to don't come, so I figured I would just in case.
Yep, it looks like you're good.
Awesome. Thank you very much.
Thank you. Have a good day.
You too.
Thanks. Hi, with the phone that says Sluss, what's your name, please?
Brandon
Brandon what?
Sluss.
And what are you here for?
It's for
Or do you have a case number?
yeah, case number 23-02644.
All right, looks like that is closed. It was closed back on January 18th. A dismissal went through. So it looks like you're all set.
Okay.
All right.
All right, thank you.
Thank you. Have a good day.
You too.
Steve, did you want to speak to put you in a breakout room with Mr. Ennis?
Hi, Heather. Yeah, sure.
All right, thank you. Mr. Beers, are you all set with Miss Walker or?
Yeah, we were not able to resolve, so we're ready to proceed with the motion.
All right, I'll have her come into the main session waiting for the judge.
Thank you.
Hey, Sammer.
Good morning.
Sandy,
Yes.
on that one that we discussed earlier, if you want to put that on Judge Oakley's that March 27th date and do it at 11:45, and I will make note to him that that's one that he has to come out and handle.
Okay, will do.
Okay, thanks.
Thank you.
Yep. Steve and Mr. Ennis, do you guys need to see the judge?
I don't know if we need to, Heather. We've agreed to, we're gonna go to mediation. We're gonna do, you know, if we could put this out 60, 90 days for some discovery, so.
We'll wait for the judge to come out and clarify that or let her know that.
Thank you.
On the Celerio 5G phone, what is your name?
My name is Amber Addington.
Amber Addington, and what are you here for? Oh, I found you. You have
Oh,
a
okay.
10:30 hearing. Are you aware that it's 10:30?
No, my paper says 9.
All right. Well, hopefully the attorney's paperwork says 9 as well.
Okay.
So we'll check on that.
And can I ask a question?
Sure.
I had applied or replied to another summons that I got, and I had not heard anything back yet, and these ones were actually pretty quick when I got my court date, and so I was really curious about that. Do I just call the court after this?
That sounds like a good idea. Yeah, because I'm not sure what you would need to do with that. Sorry.
No, that's okay. It was just you guys were pretty quick at getting me stuff in the mail after, and I hadn't received nothing yet.
Okay. Mimi, are you here for Mr. Stillman?
I am.
All right, thank you.
Heather,
Yep.
I believe that Amber Addington has a 9 o'clock also.
Oh, she does with Struckroth. Oh, okay. Well, we'll wait for that attorney to appear. Judge, sorry, just so you know, Welch versus Mockler is ready, and so is Capital versus Walker at 9 a.m.
Thank you, ma'am. This is 230253. I'm sorry, everyone. Good morning. Today is Tuesday, March 5th, 2024. I am Judge Martin. This is courtroom number 1. If you receive invitations from court staff to go into breakout rooms, please go there. The parties will be allowed an opportunity to speak before your case is called. This courtroom is scheduled to do arraignments this morning. Any arraignments that come through will take priority. There is one pending right now, so we will try to get through as much of the 9 and the 9:15 docket as possible before we need to call that criminal matter. First up is 230263 GC Capital One versus Renee Walker. Your appearances, please.
May it please the court, Your Honor, Jeffrey Beers, P 41693 on behalf of plaintiff Capital One.
And ma'am, state your name for me, please.
Renee Walker.
Thank you. Today is the day and time scheduled for the pretrial and plaintiff's motion for summary disposition. The parties have had the opportunity to speak. Mr. Beers, how are we proceeding this morning?
Your Honor, we had an opportunity to speak in breakout room. We were not able to resolve this morning, so plaintiff is prepared to proceed with motion for a summary.
Please proceed with your motion, sir.
Your Honor, this is plaintiff's motion for summary disposition based on a default on a credit card. There's been no written response to our motion, no affidavit filed by the defendants in response to our affidavit, no documentary evidence filed by the defendant to rebut our exhibits. Therefore, our motion is unopposed. MCR 2.116 G4 requires a written response. Otherwise, judgment shall enter against the defendant. Further, the defendant did not file any answers to our request for admissions, having the legal effect that all elements of our case have been legally established under MCR 2.312 B and D. It's my understanding she's really not disputing the debt, is simply financially not able to make any offers at this time. As our motion is unopposed, we ask that it be granted and that judgment enter in the amount of $2,966.81. It represents damages of $2,871.81 for costs of $95 for a total amount of $2,966.81.
Thank you. Ms. Walker, your response.
I can't afford the amount the attorney listed right now. I'm currently already in debt and I'm basically living paycheck to paycheck. So I'm not disputing the debt at all. I take full responsibility for it. I just asked for a little more time in trying to get my funding together to pay Capital One back.
Anything else, Ms. Walker?
No.
Anything else, Mr. Beers?
Plaintiff has nothing further.
Thank you. Ms. Walker, inasmuch as your indication on the record is that you don't dispute the debt, the court is going to grant the plaintiff's motion for summary disposition. Will enter the judgment as requested with principal damages of $2,871.81. There's $95 in court costs. The total judgment will be $2,966.81. Ma'am, there's a possibility that you may be able to speak with Mr. Beers to set a payment arrangement or contact his office. Mr. Beers, I don't know what your preference is. And if you're unable to come up with a payment plan with the attorney's office, ma'am, you can file a motion with the court asking the court to set the payment plan, okay?
Okay.
Mr. Beers, are you able to speak with Ms. Walker this morning about a payment plan, or is it best for her to call the office?
She can give me a call because I have a 9:15 hearing in your court. I'll give you my direct phone number. It's 248
Okay.
786
Okay.
3134.
Okay. Thank you.
Thank you. Ms. Walker, you're free to go. You have a great day, ma'am.
You too. Thank you, ma'am. Bye-bye.
Thank you. Mr. Beers, in 2301390 GC Capital One versus Thomason, there was a consent judgment submitted, correct?
That is correct. I just want to make sure the court received that.
Mr. Thomason is here. I'm letting him into the main session right now. I signed it yesterday. I'm not sure when it was filed, but that was the first time I saw it. Mr. Thomason?
Good morning.
Good morning, sir. The court has signed the consent judgment in 2301390 GC Capital One versus Thomason. You should receive a copy from the court in just a few days.
Oh, okay.
Anything else, sir?
Nope, that's just what I worked out with Capital One on the other day when I signed the agreement with them, correct?
I agree.
Yes.
Okay.
Anything else, Mr. Thomason?
No, that's it. I greatly appreciate you for your time today.
No worries. Anything else, Mr. Beers?
Nothing further. Thank you, Your Honor, and have a good day.
Have a good day. This is 240152FY, State of Michigan versus Eric Johnson. May I have your appearances, please?
Respectfully, Your Honor, Stammer Jadala, P62186, MIDC Arraignment Counsel, appearing on behalf of Mr. Johnson. Your Honor, for purposes of today's arraignment, we'd waive formal reading and stand mute. Mr. Johnson understands what he's being charged with as well as the possible penalties. I've gone over his rights. He does understand those. At this time, we're respectfully requesting court-appointed counsel moving forward for all further proceedings.
State your name for me, please, sir.
Eric Johnson, Senior.
Mr. Johnson, were you able to hear Mr. Jadala just now?
Yes, ma'am.
Sir, he's waived your right to have the formal reading of the complaint against you. He's having you stand mute to the charges. As he's indicated, you're entitled to representation in this felony matter. If you're unable to afford to retain an attorney through your own resources, the court is able to appoint one for you. Attached to the front of your file was a request for court-appointed attorney. The court has signed that, and you will be assigned an attorney going forward. It will not be Mr. Jadala. It will be someone else who relies on the information that you've provided to be in contact and communication with you. Sir, you're also entitled to pretrial release. There is a bond recommendation from Romulus Police Department asking that your bond be set at $5,010%. And the condition of the bond being that you have no contact with the complainant, Diana Hanson. Mr. Jadala, your position on bond.
Your Honor, I've actually spoken to the representative from Romulus who's at the jail now, and he says that he does not have objections to a personal bond. He understands that the complaining, the alleged victim in this matter, and Mr. Johnson do not live together, so there should be no reason that they have any contact with each other. Your Honor, I'll let him make those representations on the record if he'd like, but that's what he represented to me.
Thank you. Mr. Johnson, based on the representations of Mr. Jadala, the court will set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by this court until this case is resolved in its entirety. Condition of your bond is that you have no contact with Diana Hanson. Sir, no contact means no contact, no direct contact, no contact with third parties, no contact through social media. Should this court receive reports that you've made efforts to be in contact or communication with this person, it could be viewed as a violation of the terms of your bond. Your bond could be revoked and you could spend the rest of these proceedings in custody. Do you understand?
Yes, ma'am. Totally understand.
That being said, Mr. Johnson, your next court day will be March the 13th, 2024. That's a Wednesday at 9:15 in the morning in courtroom number 2 with Chief Judge Brian Oakley. Again, this case number is 240152 FY. Next appearance date, Wednesday, March 13th, 2024 at 9:15 a.m. in person in courtroom number 2 here at the 34th District Court. Mr. Johnson, you have the additional matter that you owe the court $246 on an unrelated fishing without a license citation. Please come and take care of that matter with the court's collection department sooner rather than later, okay?
Yes, ma'am. I thought I paid.
Anything else, Mr. Jadala? Sorry.
Nothing further, Judge. Thank you.
Was there something else, Romulus?
No, Your Honor, we were all set. Thank you so much for your time.
Thank you. Have a good day.
You as well.
Thank you, Your Honor.
This is 2301787 GC, Kenneth Welch versus Michael Mockeridge and M&S and Company. Your appearances, please.
Good morning, Your Honor. Todd Ennis, P61124 on behalf of Kenneth Welch.
Good morning, Your Honor. Excuse me, Steve Robinson appearing on behalf of defendants.
Good morning. Today is the day and time scheduled for the pretrial in this matter. How are we proceeding, Mr. Ennis?
Your Honor, we had an opportunity to speak with Mr. Robinson. I think we're both in agreement that mediation would probably bode well for these parties. I believe that the court is affiliated with the Wayne County Alternative Dispute Resolution Center. So I was hoping we could get a referral to them for possible mediation. And if not, hold this over for 60 to 90 days so that we can complete discovery if we can't get this settled.
Do you want discovery order in addition to the referral to the Wayne County Alternative Dispute Resolution Center?
Yes, Your Honor, just, as long as it's
Okay.
open.
So Sandy from the Civil Department is on. We will make sure that that gets done, that referral. Court will open discovery to commence immediately and for a period of 60 days. We'll set you on the court's adjourned pretrial on May the 7th at 9 a.m. That's more of a control date to make sure that you get over to the Dispute Resolution Center if you need something back from us. If we find out that the day we'll receive notification that the date regarding your mediation makes that May 7th date too soon, we can make adjustments on our calendar, but I just want something to control your movement through this building. Was there
Thank you, Your
anything else, Mr. Ennis?
No, Your Honor, thank you.
Mr. Robinson, anything?
No, Your Honor, except I concur with Mr. Ennis. It's my understanding that the dispute resolution, if they get the referral from the court, that you don't have to pay the fee. So, or there's a discounted fee or something when there's a referral from the court. So Todd, I guess as soon as we get that, do you want to give them a call and we can set up a date?
Sounds good.
Okay. Thank you, Judge.
Thank you.
Thank you, Your Honor.
Have a good day, gentlemen.
Likewise.
You too, Judge.
This is 2300699 GC UHG versus Amber Addington. Your appearances, please.
Good morning, Judge. Attorney Richard Stuckroth here for the plaintiff, UHG1 LLC, P85814.
This is Amber
Ms. Addington, turn your video on, please, and state your name.
Oh, I'm trying, Your Honor. It's Amber Addington. And I'm here on a debt.
Ms. Addington, have you had the opportunity to speak to the attorney?
I have, yes.
Sir, how are we proceeding this morning?
Thank you, Judge. We would be proceeding with entry of judgment here. We were able to speak with Ms. Addington prior to coming before yourself. She had stated that she had completed all of her quote-unquote homework with her bankruptcy attorney, so it seems like the filing is imminent. However, she did agree to a $25 a month payment plan in the event that that bankruptcy does not go through right away. So again, we would just ask for the judgment. This would likely be included in her bankruptcy if and when that is filed. And in the event that that falls through, we do have a payment plan.
The judgment amount, sir?
That would be in the amount of $2,790.35 plus all costs and fees.
Okay, and those numbers, sir?
One moment. I'm seeing the $75 filing fee, $20 motion fee, $38 service fee, and an additional $50.79 service fee.
Yeah.
And sir, was this going to be a consent judgment?
Yes, that would be a consent judgment.
Ms. Addington, were you able to hear the conversation I was just having with the attorney?
Yes, I was, Your Honor.
And ma'am, is it your intention this morning to enter a consent judgment that indicates that you owe this amount to UHG, the principal damages of $2,790.35? Not quite $200 in cost, Mr. Stuckworth.
Yes.
Didn't add it up, but ma'am, you were consenting to entry of judgment.
Yes, Your Honor.
And ma'am, because you appear on Zoom, there was not a signed document presented to the court. Was there some conversation about how this consent judgment will be executed and forwarded to the court?
There was not a communication as to that, Your Honor, but I can certainly send it to Ms. Addington via email.
Ms. Addington, the attorney's office will send you the consent judgment with those dollar amounts that were just placed on the record. If it's what you wish to agree to, sign it, send it back to him, and then he will file it with the court.
Okay, Your Honor.
As a control measure, ma'am, the court will set this matter for an adjourned pretrial on April the 2nd at 9:15. If the paperwork is signed and returned to the attorney's office and they file it with the court, you will not need to appear, but we need to set dates to keep matters moving along, okay?
I understand, Your Honor.
And ma'am, if you complete that bankruptcy filing, please be sure to relate this matter to the bankruptcy attorney, either through a copy of the judgment or an inclusion in your bankruptcy filing, okay?
All right, Your Honor.
Was there anything else on behalf of UHG?
No, Your Honor, thank you.
Ms. Addington, anything else in this case?
No, Your Honor.
Thank you. Ma'am, I know you have a case at 10:30. If you want to leave and come back, I understand, and I'll see you this a little bit later, okay?
Okay.
Thank you.
Thank you, Judge.
Thank you, Judge.
You're welcome. This is 2300407 GC. This is Crown Asset versus LaShawn Webb. Your appearances, please.
Good morning, Your Honor. May it please the court, Mimi Kalish. My P number is 52383, appearing on behalf of the plaintiff.
Thank you. Ma'am, unmute yourself and state your name for me, please.
Good morning, Your Honor. This is LaShawn Webb.
Thank you. Today is the day and time scheduled for the adjourned pretrial and the motion for summary disposition. Have the parties had an opportunity to speak this morning?
No, Your Honor.
Not this morning, Your Honor.
Or would you like the opportunity to speak, or are you prepared to proceed?
I am prepared to proceed. The defendant has called our office a couple of times, and I'm prepared to move forward at this time.
Please proceed, Ms. Kalish.
Your Honor, today is the date and time for plaintiff's motion for summary disposition brought pursuant to MCR 2.116 C9 and/or C10. It's plaintiff's position that the defendant has not put forth a valid defense, and there are no material issues of fact for the court to decide as it relates to defendant's default of a credit card agreement originating with Comenity Capital Bank. The amount in dispute, Your Honor, is $12,033.42. Plaintiff has incurred $315.44 in costs, and we would be also asking for a $75 statutory attorney fee set by the state of Michigan. The proposed summary disposition judgment would be in the amount of $1,433.86. I should indicate that there was no written response to the motion. And I don't believe Ms. Webb is disputing the debt. It may be inability to pay or to enter into a payment plan at this time. But that notwithstanding, that doesn't set forth a legal defense. And unless the court has any questions for me, we would ask that the motion be granted and a judgment entered at this time.
Thank you. Ms. Webb,
Yes, ma'am. May I?
your
proceed?
response to the motion? Yes.
Yeah, so response was filed to their motion. And I do have email confirmation that a response was filed. It's a couple things I would like to address. I have reached out to a plaintiff in regards to attempting to resolve this. After our last meeting here, we did discuss, talking to see if we can reach some sort of settlement. I sent over an email just to start negotiations, and I didn't get a written response back, but I did actually receive a phone call, but that wasn't until last week, Your Honor. And so prior to that one phone call from Stillman's office, I hadn't received anything from Crown Asset Management prior to this lawsuit actually being filed. And so in my response that I wrote to the motion that plaintiff filed, one of the issues I took was the fact that prior to the lawsuit being filed with this court, there was no opportunity for me to seek any type of validation for the debt. And looking through the documents that plaintiff submitted, I see Exhibit B shows a bill of sale, but I'm not showing anything that specifically states my account on here. And then looking at the amount that plaintiff put in their motion of the $12,033.42 plus the added court costs, and obviously the attorney fee, it didn't match with the actual final statement that was included with the 100 or so pages that they submitted, which showed an ending amount of $11,714.81. So I'm not disagreeing that there was a agreement entered with Community Bank. I'm disagreeing about the final amount that is being sought by the plaintiff. I think that's an error. And also about actually giving me time to even attempt to get this validated prior to the Stillman office filing suit on behalf of Crown Management.
Anything else, Ms. Webb?
No, that's all for now, Your Honor.
Anything else, Ms. Kalish?
Nothing further, Your Honor.
Thank you. The court did receive both plaintiff's motion and defendant's response to the motion. And respectfully, in reviewing the response, Ms. Webb does not assert that she does not owe this amount. The issue was regarding communication at the onset of, I'm sorry, the lack of communication before a lawsuit was filed, alleged lack of communication. But that being the case, and the court having had the opportunity to review the attachments to plaintiff's motion, the court will grant plaintiff's motion for summary disposition pursuant to MCR 2.116 C9 and C10 for the amount prayed for. Ms. Kalish, if your office did not already have an order attached to the motion, please attach it or submit it to the court on base, and the court will sign it.
I will do that, Your Honor. I will upload an order.
Thank you. Was there anything else, Ms. Kalish?
Nothing further, Judge.
Anything else, Ms. Webb?
Well, Your Honor, I'm just looking at the documents that Stillman Law Office submitted, even in the documents they sent to you, that the supporting information they have here doesn't match with the amount that they placed on in their motion. So the final amount from Overstock does not match with what they were actually seeking. And that, even in looking at this, is not factoring in court costs, because that's something additional on the amount that they're claiming here.
Ms. Webb, the court received your response to the motion, and your response to the motion for summary disposition, which would the motion, their motion being quite lengthy, your response was regarding the communication. There was no dispute as to the debt. The court has to rely on the motion and the response that was filed, and that's why I asked you, was there anything you wanted to say? The court has made its ruling, ma'am.
Thank you, Your Honor.
Have a good day.
Thank you.
Thank you, Your Honor.
Heather, if you want to let those people in
Yep, I was just waiting for you to be done.
to be quiet, I understand. Thank you.
Mhm.
All right, just wait till, we're gonna go on a court hearing in a minute. I might need to get you on the phone. We are. All right, I'll call you back.
Hi, Mr. Nykel.
Good morning, Judge. How are you today?
Did you want to speak to J&M Towing in a breakout room?
Sure.
All right, and
I don't know what, do they have representation? Or are they
no.
showing up? And nobody's here from Best Asphalt, correct? Where the vehicle was towed from?
Not that I know. Chantel Sims, what are you? Who are you?
He's a tow truck driver, Your Honor.
It's not me, it's Heather.
I was a towing company that was originally hired to tow the vehicles from Best Asphalt's property.
Yeah, he was subpoenaed by us, Your Honor, to testify if we need him.
Mr. Nykel, that's not me. That's Heather trying to get you connected. So give me one moment. But your case is scheduled at 9:30. Let me clear up some of these 9:15 matters.
All right, very good. Thank you.
Thank you. This is 2302988GC. This is Bank of America versus Petronella Gavanchu. May I have your appearances, please?
Good morning, Your Honor. Sandra Francis on behalf of plaintiff.
Good morning, Your Honor.
State your name, please.
Petronella Gafencu.
Thank you, Ms. Gafencu. Today is the date and time scheduled for the motion for summary disposition that was filed by plaintiff. Ms. Francis, had you had the opportunity to speak to the defendant this morning?
I have, Your Honor. It doesn't appear that they're disputing the debt. However, they are citing financial hardship as the basis for being unable to pay this debt. They've indicated that they may be filing bankruptcy. I'm not sure if that's the route that they will be taking, but there is no resolution at this point in time.
Thank you, ma'am. Please proceed with your motion.
Your Honor, our motion is unopposed as the defendants had failed to file a written response to the motion. It's pursuant to MCR 2.116 C9 and C10. Ultimately, Your Honor, this is for a credit card debt. The account was opened April 19 of 2021. The last payment made was January 13 of 2023. The account was then charged off on August 31st of 2023. The defendants do not dispute that they owe this debt. As I've indicated, they're simply citing financial hardship. At this point in time, Your Honor, I would ask that our motion be granted, given that there is no valid legal objection.
Ma'am, your response to the motion?
The financial hardship is not allowing us to be able to even settle for the smallest lump sum amount that they're offering, nor the payment plan. It's way out of our budget. We're barely trying to make ends meet with just food on the table at this moment.
Is there anything else, ma'am?
No.
Anything else, Ms. Francis?
No, Your Honor.
Thank you. The court, having had the opportunity to review the plaintiff's motion for summary disposition, noting that the defendant did not file an answer to the motion, but in the answer that was filed originally in this case expressed the financial hardship, court will find that there is not been a genuine issue of material fact or a defense asserted, will grant the plaintiff's motion for summary disposition in this matter, and the amount paid for in the motion plus all recoverable court costs Ms. Francis, if there was not already an order submitted to that regard, please submit it through OnBase. The court will sign it. A copy will be mailed to you, Ms. Gafincho. And if, as indicated at our first appearance, and again today, your intention is to file bankruptcy, please make sure that this is included in that bankruptcy filing. Is there anything else this morning, Ms. Francis?
No, Your Honor, thank you.
Anything else, Ms. Gafincho?
No, Your Honor, thank you.
Thank you. That concludes this matter, ma'am. You're free to go. Good luck to you.
Thank you.
Thank you. Have a nice day.
You too, Ms. Francis. This is 226083 LT. This is the estate of Kenneth Lucho versus Ralph Carew.
Here, Your Honor.
Turn your video on. State your name for me, please, sir.
Don't know. What do I click on to turn it on?
It will look like a little video camera.
Oh. Did that do it? Okay, there we are, Your Honor.
Wonderful. Yes. State your name for me, sir.
Ralph Carew.
Thank you, Mr. Carew. Have you been in contact with the attorneys for your landlord?
No, Kenneth is deceased.
I understand that, sir, but someone
Okay.
was representing the estate.
Yeah, no, I haven't. I received a summons to come here. Kind of puzzled about it. I know.
Sir, the court,
Go ahead.
I'm sorry to cut you off. The court scheduled this matter for hearing today. It was scheduled at 9:15. It's now 9:28 by this court's clock because judgment entered in this case back on January 18, 2023. And then the court received an application for an order of eviction on February 2nd, 2024. That's beyond the time that an application will be granted without a hearing. So I asked the civil department to schedule it for hearing so we could figure out why more than a year later, they were asking to have you physically removed from the property. Are you still at the property?
No.
Oh,
The new owner took over the property on February 7th.
of this year?
Yep.
Well, sir, you have appeared, they have not. It is their petition. They're failing to appear. The court will deny an order of eviction. That concludes the matter, Mr. Carew. You may exit that room through that door to your left.
Thank you, Your Honor.
Have a great day, sir.
You too. You just made it a lot
Thank you.
better. I didn't understand why it was going on, but now I'm fine. Thank you, Your Honor. Have a wonderful.
You're welcome, sir.
blessed day.
You too.
Do I have to turn something off?
Nope, the court staff will come in and reset that computer. That's why I say you can just leave through that door on
All
your
right,
left. You're
thank
fine.
you.
You're welcome. This is 2302716 GC Andover Farms versus Nwoku. Your appearances, please.
Morning, Honor. Brian Kelly on behalf of Andover Farms.
Sir, turn your video on. State your name for me, please.
Ike Nwoko.
Thank you. Today is the day and time scheduled for the adjourned pretrial in this matter. The last time we were here, the parties asked for an adjournment to allow time for Mr. Nwoku to verify that he made payment that was requested by the HOA. Mr. Kelly, how are we proceeding this morning?
Your Honor, we've had an opportunity to talk several times on this. Plaintiff or defendant has provided me proof of payment that we'd already had seen, and that was Mr. Nwoku thought that had not been credited properly. There's one payment that I am waiting for from him. I emailed him a couple of days ago and asked if he could send me an updated copy of it, and I don't know if he was able to get it. So it looks like he had a check issued, but I can't tell whether it was cash cleared or applied because I need to see the back of the payment. And that's all I'm waiting on.
Your Honor, good morning. There is no check issue. I have all the evidence that I collected.
Mr. Nwoku, I'm sorry, sir, would you turn your video on for me, please?
Oh, sorry.
That's okay. You were saying that you've turned over everything?
Yes, I've turned over everything except the last one, which I just got, I think yesterday, showing that all the payments were made on time, except the 2020, which was the COVID year. That was the only payment that was made late in March, but every other payment was made the first week of January, and I have all the evidence which I have presented to him. I
And
have
that's where,
all the evidence.
and that's where we're in disagreement. I've got a screenshot from a bank that shows that a check was issued, but I've asked for the back side of it. And if it came in yesterday, I still do not have a copy of it.
Mr. Nwoko, if that's showing your account number, move that off the screen, please. Thank you. I'm sorry, Mr. Kelly, you were asking for the back of a check, a singular check at this
Just a
point?
singular, and I've explained to Mr. Nwoku that all of those checks have been credited properly. He is missing a payment from 2023 that is not showing up anywhere, and that's the only one that's in dispute. And it sounds like he may have gotten what I was missing yesterday. Oh, and all I keep getting is an email saying, yes, I made it, but I don't have proof of it other than him saying he's made the payment. I've seen a screenshot showing the check was issued. So that's where the only discrepancy is. So he's admitting that he was late and there were late fees and fees assessed to the account in 2020. It's just a matter of what the total balance due is. And so if he provides me that, then I can verify it really, really quick. And if it doesn't exist, then
it does exist. I have it right here. I can mail it to the court. The reason why
I don't need it mailed to the court, sir.
Hold on, Mr. Kelly, no. No.
Sorry.
Mr.
Sorry, Your Honor.
Nwoko, you were saying?
I can mail it to the court. The reason he didn't get it up to now was I got it, I think, yesterday. And apart from that, I have been having communication with him. And each time he asks me to get something, I get it. He comes back to say, that's not enough, get this more. Initially, he did not ask me to get the 2023. But then when I provided him all the evidence that he requested, and then he came back to say, okay, get me 2023.
Mr. Nwoko, Mr. Kelly has just said on the record that the only thing outstanding is the 2023. Do you, in your hand right now, have something that shows that payment was made to Andover Farms for 2023? Don't show me,
Yes,
I'm just asking you to answer. Do you have it in your hand right now?
I have it right here, yes.
You have proof that that check or transfer occurred?
Yes, I have it right here.
Then Mr. Nwoko, do one thing for me. Go into the breakout room with Mr. Kelly right now and show him on the screen. And when you come out, if his position is that it's not sufficient, the court is happy to schedule a matter for trial. You will come in person, bring your documents, and then the court will make a decision. So
Okay.
please go into the breakout room with Mr. Kelly, show him that the proof of the 2023 payment to the HOA. And when you come back out, I'll recall the matter, okay?
Thank you.
Thank you, Your Honor.
Thank you. This is 2400518GZ. This is Paul Pabzian versus J&M Towing and Romulus Police Department. Your
Morning,
appearances, please.
Edward Nykel, P42017, appearing on behalf of Paul Papazian, who's present with me to my left, and I'm going to turn my video on.
Thank you, sir. And ma'am, your name for the record?
My name is Alexander Pape.
She said, "Man."
My name is Valerie Welch on behalf of J&M Towing.
And ma'am, what's your position with J&M Towing?
I'm the office manager.
Are you an officer or owner of J&M Towing?
I am the office manager. My mother owns it.
Corporations legal entities are represented by attorneys, and that's why I'm asking you what your position is with the company. Is there a reason why there's not an attorney present for you this morning?
This is the first time I've done this. I wasn't aware that I needed a legal attorney.
Well, you're representing the legal position of a corporation and allowing you to proceed unless you're a licensed attorney in the state of Michigan will be allowing you to practice law without a license. This court's not inclined to do that this morning.
So with that being said, would we need to reschedule?
Yes, ma'am.
Okay.
Do you have an attorney for the corporation?
Yes, we do.
Okay. We can reset this matter for I want to make sure that Mr. Papazian, I'm sorry,
Yes, yes, Your Honor.
has wanted to make sure he's retrieved the vehicle and paid the fees before I put it out for a month, which is what I'm looking at right now. Mr. Nykel?
Your Honor, I believe he's posted a bond.
No, I paid J&M Towing.
Oh, paid J&M Towing the fees, yes, and then paid, I think there was a $40 fee too, as well to the court.
205.
I understand that, but my question was, it was my understanding from reading the petition that he's paid J&M and has retrieved the vehicle. My concern is putting a matter over for a month if he doesn't have the vehicle.
Yes.
No, that's not a problem, Your Honor, but I do want to address one thing about putting it over. You know, J&M Towing is sort of a third party in this whole process. The real party in interest that precipitated J&M Towing to even be moving these vehicles was Best Asphalt, Charlie Stefanko, the owner, who my client had a rental lease agreement with month to month to store the vehicles on Mr. Stefanko's yard at Best Asphalt. And
Mr. Nykel, have you seen the petition that was filed in this case?
yes,
Okay, I don't see that name on here. The only name listed on here is J&M Towing. And at the bottom, it asks for notice to go to the petitioner, R. Ferguson, as a secure party, Romulus Police Department, and J&M Towing. So you mentioning this Best Asphalt, their name doesn't appear on the people who should be respondents or notice to appear this morning.
yes, because as I understand it, this is a petition that questions the reasonableness of the towing charges and or the fact that it was towed in the first place. It was not the property should not have been deemed abandoned, but it was by the Romulus Police Department. And in fact, when I look at the police report, it looks like the vehicles had already been towed from Best Asphalt to J&M's yard when the police were even contacted. So there's a problem ab initio here from the very beginning, where there's a party here that really is the asphalt company that moved the product. It had this moved in the first place. It must have contacted J&M to have.
And
the
Mr. Nykel,
proper-
that's my, I'm sorry to interrupt you, sir, but that's my point specifically, that you've now mentioned Best Asphalt twice as being involved, and I'm saying to you, their name doesn't appear on the petition. And if you're saying that it should not have been deemed abandoned, and they were part of moving the property, moving the vehicle from the premises, right?
Yes.
Or maybe, am I not understanding your argument?
Well, see, but the citation that was issued, right, was only had J&M on it. It didn't have anything about Best Asphalt.
Can I say something?
Your Honor, my client would like to add something to that.
Your Honor, when I went to the court to petition this whole thing, I stated that Best Asphalt was the landlord and they had it towed. And the gentleman at the window said, well, their name's not on it. You can only go against J&M.
So we've been linchpinned somewhat in this regard, Your Honor, by proceeding. My client actually filed a petition and then later brought me aboard. And was originally a hearing date scheduled, and we were trying to get someone subpoenaed, the tow truck driver, Chantel Sims, who's waiting as well. So this matter was put off, but I fully intended to, and I believe that a necessary party in this whole process has got to be Best Asphalt. There's no way that this property should have been deemed abandoned. It was the rental was paid through December 31st of 2023, and the vehicles were towed on January 4th. My client was out of the country at that time. Never got any.
Which goes back to my original. If we adjourn it for a month, J&M Towing will retain counsel. And then, Mr. Nyko, is it your intention to have Best Asphalt added as a party?
I believe they should be, Your Honor. I don't know exactly how to do that with the court when the court wouldn't allow my client to even get them involved from the beginning through the clerk's office. I guess do I have to file a motion to amend the complaint? Or is this sufficient to verbally present it to Your Honor at this time and ask that the court deem them to be a necessary party who needs to be given notice and needs to appear?
It's a two-part thing. First of all, the court staff processes paperwork. Court staff have been well trained to know and understand that they are not authorized to give legal advice. That would again be the unauthorized practice of law. The court has had conversations with staff regarding that. So I don't know what happened at the counter, and there's no need to get into it beyond saying that part, period. Secondly, the court will take your oral motion to amend the petition to add Best Asphalt going forward as a necessary party. We will adjourn this matter over to the April the 2nd docket at
Your Honor, is
10 a.m.
10 a.m. Your Honor, is it possible to change that to a different date? My client is notifying me that he cannot be present on that date.
May the 7th?
Yes.
May the 7th is very good, Your Honor.
Thank you, Your Honor.
That's a little bit further out. My apologies, but it's just the way my civil docket flows. May the 2nd at that same time, 10 a.m.
2nd, 10 a.m. I just got to look at my calendar real quickly. It's a Thursday. It looks perfect for me.
I'm sorry. It should not be a Thursday. It should be a.
Oh, did you say the
It's a
2nd or the
Tuesday.
7th?
May the 7th.
Oh, I'm sorry. I thought you said-
5/7.
and
No,
then
that's
I heard
fine.
The 2nd after that. So the 7th is still.
It was April the 2nd was the first day you said your client's out of town. And so I said May the 7th, 5/7.
Yes, the 7th works very well. Thank you.
5/7 at 10 a.m.
Is there anything?
Ms. Welch, is there anything else?
Is there anything I need to do with respect to Best Asphalt, or is the court going to give them notice?
Now, back to yesterday, it's loose again.
Jamie.
I don't know what the remedy is for this shit. I don't even know, Rick.
I'm sorry, that's court staff walking through
I
Zoom
heard-
room.
I understand.
There's nothing else you need to do, Mr. Nyko. I'll get with the civil department to do what we need to do to make sure that notice goes everywhere it's supposed to go.
And with respect to the subpoena of Chantel Sims, may that be continued and just adjourned to that date?
Mr. Sims,
Yes,
you understand that?
yes, 5,
Request that you reappear on 5/7 at 10 a.m.
yes.
Very
Thank
good.
you.
Thank you, Your Honor. We appreciate it.
Thank you, Your Honor.
See you in May. Have a good day.
I know, you as well.
This is a recall of 2302716 GC Andover versus Nwoko. The parties have had the opportunity to speak. How are we proceeding?
Oh, yes, Your Honor. Actually, we got cut off in the breakout room, but Mr. Nwoko emailed me over the one item that I was missing. It looks like the payment was made timely, so he still has an outstanding balance on the account, but I know what the balance is now. But it doesn't look like he's logged back in yet.
He's here.
Okay. What I'd ask for is if Judge Green's available, if we could mediate a resolution with Judge Green. Showing the payment balance does not make sense to move forward with the trial with the court's time or with either of the parties at this point with what he's showing his own. So if we could have an opportunity to try to mediate a resolution, that I think would be the best way to resolve the matter.
Mr. Nwoko?
Yes, Your Honor. May I inform, I don't know how to speak the language, unfortunately, but may I let you know that the particular year that I was delinquent or I was late was the 2020, which was the COVID year. That was about that time COVID hit and there was panic, there was chaos. That was the only year I was late. And I was late just 2 months in that year. They received their check in March. So I don't know.
Mr. Nwoko, what Mr. Kelly has asked is that this matter be referred to Judge Green. She's another judge in this building. He's asking that she do a mediation of this case, which means you would schedule with her office to come and sit down and see if you were able to resolve the case. Is that how you wish to proceed, Mr. Nwoko?
I mean, if that's the option that is left for me, I mean, I don't mind, but based on the evidence I have provided, based on what was requested of me, which I have provided completely, I am of the opinion that we should strike this out. I made my payments. I am being sent on a run around here to prove the obvious thing, which is that I made my payments and on time, except for the COVID year. It seems that, and I will explain what was going on because Mr. Byron was sent me a list of checks or a list of years that he wanted me to provide. And in that list, there were marks on the days that they cleared their own check. So, Your Honor, what was going on was that I was—
Mr. Nwoko,
Yes.
I'm cutting you off only because today is the pretrial. If you do not want to go to mediation, this court understands and accepts that, and I'm happy to schedule the matter for trial. Are you prepared to proceed to trial, Mr. Kelly?
I'm prepared to proceed to trial, Your Honor, but it'd be unfortunate without wasting the court's time for it. I think we can resolve it through mediation.
Okay, well, let's go try mediation.
I'm sorry?
We can try mediation, but if it doesn't work the way I will anticipate it, I can call it for trial, ma'am, yes?
Mr. Kelly, it's not a waste of the court's time. I'm happy to do it either way. Mr. Nwoko originally indicated a resistance to mediation, which is fine. And I'm just asking, if we were scheduling for trial, I will schedule it for April the 2nd at 11 a.m. So, Mr. Nwoko, what is it that you want? Do you want mediation, or are you okay with mediation, or would you rather the court schedule it for trial?
Okay, we can go for mediation, but if I'm not satisfied with what the mediation came out with, I will want it to go for trial.
The case will, if you don't resolve it with Judge Green, the case will come back to me.
Exactly.
And we'll schedule. So what we'll do, okay, what we'll do is I will give it over to Judge Green for mediation, and I will schedule you to come back to me on May the 7th at 9:30. That gives time for you to get scheduled with Judge Green and meet with Judge Green. I'm just, you know what? Let me take that back. Nope. We'll refer it over to Judge Green. She'll reach out to both of you to schedule it for mediation. If you are unsuccessful at mediation, I'll have you come back here on May the 7th at 9:30. And we will call that a final pretrial and schedule trial from that date. I don't want to drag it out, but I'm just trying to figure out how to move it along. I don't want to schedule a trial date if you might not need it. So Mr. Nwoko, we want to make sure that we have a good phone number for you. So before you leave, I'm going to have you go into a breakout room with Sandy from the Court Civil Department. She's going to be the one that gets the file to Judge Green. So Judge Green will reach out to both you and Mr. Kelly to get you scheduled for in-house mediation.
Yes, Your Honor.
Is there anything else, Mr. Kelly?
Nothing further, Your Honor. Thank you so much.
Anything else, Mr. Nwoko?
Nothing further, Your Honor. Thank you so much too.
You're very welcome, sir. I'll get you moved in with court staff so they can verify a phone number for you, okay?
Thank you.
Thank you, sir. Have a good day.
You too, ma'am.
Thank you.
Thank you, Your Honor. Have a good day.
You too, Mr. Kelly. Sandy?
Yes, Judge.
Would you just verify, Mr. Nwoko, please, that this file is coming down to you to send over to Judge Green, but I want to make sure that there's a good contact.
Yep, I'll get him in a breakout room with me.
Thank you, ma'am.
You're welcome.
Ms. Love?
Yes.
Your case is not scheduled until 10 o'clock. I see the attorney popping on right now. As soon as he gets in, we'll get you connected. You can have a conversation regarding why we're here if need be. Hold on one second. Mr. Cates?
Yes.
This is 2301770 LT. This is Parkwood Manor versus Mahogany Love. I was just indicating, I'm sorry, go ahead, sir.
I was gonna say, good morning, Your Honor. Andrew Cates, P78292, standing in for the Council of Record, represents Parkwood Manor.
Thank you. And Ms. Love, turn your video on, state your name for the record, ma'am.
My name's Mahogany Love.
Thank you. The reason why this case was scheduled, Mr. Cates, was that the parties appeared back on November 1st, 2023, and the terms of a conditional dismissal were placed on the record. The court thereafter received a proposed conditional dismissal whose terms did not match what had been placed on the record. That was received on November the 14th. The next filing was received on January 29th. I asked the court staff to schedule it, and then there was some miscommunication that was not scheduled as requested in February. It was resubmitted, and I asked that it be scheduled for this morning so that we could confirm the amounts that are due and owing, if any, and have that consent judgment entered. Or not consent judgment, I'm sorry, conditional dismissal.
All right. Okay, the rent due and owing by what I have before me in the file was $9,805 with court costs and fees of $233 for a total of $10,038. The defendant was to pay $772.16 on the Friday of each week beginning November 3rd, 2023, and ending on January 29th, 2024. No further late fees would accumulate as long as defendant makes these payments timely. 4B was checked on the conditional dismissal, and it looks like her Miss Love's name was signed with permission.
Those were the numbers from November, Mr. Cates. Is that still the correct balance?
Let me see here. All right, let's see.
Ms. Love?
Yes.
Ma'am, have you been making payments since we were last here in November?
Okay, so I was only able to make about, I believe it was like 3 or maybe 4 payments. After that, my job had went into a shutdown, so I wasn't able to keep up with it.
So Mr. Gann, that being the case, if you want to take, I'm sorry, Mr. Cates, if you want to take a moment and confirm the balance, the court is prepared to enter an order.
The balance right now on this case would be $9,378. She did make payments, looks like according to the agreement, but the last payment was received on November 28th of 2023, and I am not showing any payments since then. So that's why the balance is back up to 9,378.
Ms. Love and Mr. Cates, let's get you into a breakout room. Our next case isn't scheduled until 10:30. The two of you will talk, come back out, and if there's still a conditional dismissal that needs to be entered, we'll place those terms on the record, okay?
Okay, thank you.
Thank you. Sandy?
Yes, Judge.
I'm sorry, I don't know what you need to do to move those files down to the bench.
I can work on that, Judge. I wasn't for sure if Mary
Oh.
Ann did it, or I can do it. Or I should be able to get
Thanks,
into it
Heather.
and move them all. Okay.
Thank you.
Yep. I'll work on it now.
Were you expecting Ms. Love to follow you right back out, sir?
Yes, I was actually.
Okay, let's get her, I sent her a request to return to the main session. Thank you. The parties have had the opportunity to speak. Mr. Cates, how are we proceeding?
Your Honor, we have agreed to conditional dismissal. I am noting that there is one correction I need to make. The total, because the ledger I have only went up to February's rent, was not accurate in stating the amount owed. The amount owed is $10,728 at this point in time. The conditional dismissal, however, is that the defendant has agreed to pay $400 a week until the balance is paid and current. Payments will be due every Friday, and those payments will begin on 3/15 of 2024.
Ms. Love, were you able to hear Mr. Cates just now?
Yes.
And ma'am, those are the terms of the consent judgment that, I'm sorry, the conditional dismissal that you wish the court to enter.
Yes.
Do you have any questions about today's hearing or these proceedings?
No.
Have you authorized Mr. Cates to sign your name to that conditional dismissal?
Yes.
Then ma'am, what the court is expecting is an on-base filing of a conditional dismissal that indicates that there is $10,728 due and owing in this matter. And that Ms. Love will make payments of $400 per week, beginning on March the 15th, 2024, and continuing on each Friday thereafter until the account is current. Ma'am, so long as you make these payments, this matter will stay dismissed. If you fail to make the payments, the plaintiff's office may file an affidavit to ask that this matter be reinstated, judgment enter against you, and that they move to evict you. Do you understand?
Understood.
Thank you. Mr. Cates, if you would have your office submit that conditional dismissal as soon as possible, we'll get it signed. The numbers have been confirmed for the record. Is there anything else on behalf of the plaintiff?
No, Your Honor. Thank you.
Anything else, Ms. Love?
Do I get a copy of that at all, or?
Yes, ma'am. They'll file it online. We have an online system to file documents. I will sign it as soon as I see it, and then the staff will mail it out to you.
If you have any problems, come out and grab one of us.
Okay. Do you know how soon, I'm only asking because I still haven't received the last one.
There was no last one because it didn't match the numbers that were placed on the record, which is why I've taken the time to go through and make sure that we have the correct balance.
Is
You
that
look confused,
because
Miss Love.
is that because they added all the way up until February on there?
No, ma'am, when we were here back in November,
Right. And what she did was she added all the way up until February.
but what I'm saying, ma'am, is that those were not the numbers that were placed on the record. The court was only going to sign what was identical to what the parties agreed to on the record. And now that you've agreed to this amount on the record, I will sign that order. There was no order signed before.
Oh,
You look
okay.
confused.
Well, I mean, I still don't understand that, but okay.
Which part, Miss Love?
I didn't understand that there wasn't anything signed when this was stated before.
What I'm saying, ma'am, is, and I said it at the beginning, and maybe I didn't say it clearly. We were
No,
here on November
I
Oh,
understood that. I apologize. I understood that. I didn't understand why it didn't match. That's all.
I don't know why. I know what I wrote down regarding the number on November the 1st, and then the document I received on November the 14th had a different number. And if it was because it was calculated out, then it should have been indicated on the record or on the filing. But now we've talked about it. The numbers are certain. Mr. Case's office will send over the agreement for $10,728 with $400 due every week. I will sign that as long as those numbers match what I just said. And then you'll get a copy in the mail.
Okay.
Anything else, Miss Love?
No.
Judge,
Thank you, ma'am. You have a good day. Yes, ma'am.
before I go, can I get Miss Love in a breakout room so I can get her email address?
Absolutely. Anything else, Mr. Cates?
No, Your Honor, thank you.
Have a good day.
Thank you. You as well.
Judge, I'm just waiting on Attorney Jadala. I did send him the info and we've got the defendant in breakout room number 6. So I'll put the attorney in there when he gets here.
Thank you. And Tim just handed me the file, so.
Perfect. She set a payment plan on her 2 sentenced cases when she was downstairs with Vanessa. But the third file in your stack is one that she set a payment plan on, but she still owes work program. I believe it's 7 days. So I wanted to include that so that part of it could be addressed.
Miss Love, did you speak with someone? Oh.
Judge, I'm gonna step away for a few minutes and I will be back.
Thank you, ma'am.
On YouTube?
Yeah, you know how to do stuff on practice. 30 times and everything.
Chelsea, it'll be just a moment. We'll get your case called, okay?
Okay, thank you.
You're welcome.
This is 220702FY. This is State of Michigan versus Chelsea Crippen. May I have your appearances, please?
Respectfully, Your Honor, Sam Richardala, P62186, MIDC Arraignment Counsel, appearing on behalf of Mrs. Crippen. Your Honor, for purposes of today's arraignment on both the felony matter and the misdemeanor matter, we'd waive formal reading and stand mute. Ms. Crippen understands what she's being charged with as well as the possible penalties. I've gone over her rights. She does understand those, Your Honor. At this time, she is respectfully requested court-appointed counsel moving forward.
Thank you, ma'am. State your name for the record, please.
Chelsea Crippen?
Ms. Crippen, were you able to hear Mr. Jadala just now?
Yes, ma'am.
Ma'am, he's indicated that you waived the formal reading of the criminal complaint against you. He's having you stand mute to those charges. He's asking that a court-appointed attorney be assigned to you. You have an absolute right to be represented by an attorney in this matter. If you're unable to afford one through your own resources or that in friends and family, the court is able to appoint one for you. There was a petition for court-appointed attorney attached to the front of your file. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Jadala. It will be someone else who relies on the information contained on that petition to be in contact and communication with you. Ma'am, you also have a right to be considered for pretrial release. The bond recommendation from Romulus Police Department is from October 12th, 2022, and requests a bond in the amount of $25,000, 10%. Due to your reputation or character. Mr. Jadala, what say you to that bond recommendation?
Your Honor, respectfully, I will say that Mrs. Crippen has walked in voluntarily today. She's 32 years old. She is not employed. She is a mother of one child who's 3 years old. She's not on probation or parole, and she's currently, Your Honor, prior to this arraignment, she's entered into payment plans for her two outstanding matters, Your Honor, and she's asking that the Romulus driving while license suspended be set for a pretrial and these matters be set for a PCC so she can handle these matters. We respect her request that you consider her personal bond. She will appear as ordered, Your Honor, and once again, she did walk in.
Thank you. And Mr. Jadala, the court appreciates that Ms. Crippen walked in, but the court has some concern that she failed to appear back in January of 2024, and the matter was set for show cause for February 21st, 2024. She failed to appear again. Her bond was forfeit. That being the case, and giving her credit for having walked in the day, the court will set the bond at $10,000 personal. Ms. Crippen, you do not need to post any money, but what you must do is continue to appear as directed by this court until this matter is resolved in its entirety. Your next appearance date in this felony case will be Wednesday, March the 13th, 2024 at 9:15 a.m. It will be in courtroom number 2 with Chief Judge Brian Oakley. Again, this is 220702FY. Next appearance date, March 13th, 2024 at 9:15 a.m. Ms. Crippen, court staff will give you notice of that date before you leave the building today. The other matter was 23RP06538 AOT. This was City of Romulus versus Chelsea Crippen. Mr. Jadala has already indicated that you're entering a plea of not guilty in this case. This is the driving while license suspended from December 16th, 2023. Ma'am, the court will set your bond in that matter at $5,000 personal. Again, you do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety.
Thank you, Your Honor.
Your next appearance date for this case for the driving while license suspended will be April the 1st, 2024 on Zoom at 8:15 a.m. with Al Hinman. 23RP 6538A. Next appearance date, April 1st at 8:15 a.m. And then last, there was 1700180T. This was a City of Romulus case, ma'am, for failing to display a valid license where you owe the court 7 days on the work program. The warrant has been canceled in this file. And Ms. Crippen, the court no longer runs a work program. So what we will do is convert the work program days to community service days. "24 hours of community service in the next 90 days.
Okay.
Do you have a nonprofit agency that you're able to get those hours done, ma'am?
Yes, ma'am. I have my own nonprofit.
24 hours of community service within the next 90 days with documentation to the court's probation department.
Okay. Yes, ma'am.
Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Ms. Crippen, good luck to you, ma'am. Before you leave, court staff will be able to give you notice, paper notice for those return dates on
Thank
the
you.
driving while license suspended and the felony matter.
Thank you, Your Honor.
You're welcome, ma'am. You don't need to do anything. Just exit through that door on your left and court staff will come reset that computer.
Okay. Have a great day.
Thank you.
Thank
You too. Ms. Ellison, were we ready with Ms. Addington?
We are, Your Honor.
This is 2302619 GC Collins Asset Group versus Amber Addington. Your appearances.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
This is Amber Addington.
Good to see you again, Ms. Addington. Today is the day and time scheduled for the pretrial in this matter. How are we proceeding?
Your Honor, I think we just need a scheduling order. It's my understanding from her answer that she does plan on filing bankruptcy, but it hasn't happened yet. So I guess we just proceed, and then if bankruptcy occurs, then we'll address accordingly.
Ms. Addington, how long do you anticipate before your bankruptcy is filed?
Your Honor, I have all of my paperwork turned into my lawyer, all of my documents. They're reviewing all of them. I spoke with them on Friday morning, and they're in that review process. So I'm waiting for them to let me know what my next steps are.
Ms. Ellison, we'll adjourn this matter over to May the 7th.
Okay.
May the 7th. At 9:15 a.m. Ms. Addington, that will give you time to either get filed or figure out how we will otherwise resolve this case.
Yes, Your Honor, I am going to contact them today to let them know about what happened in court today, and hopefully they'll push it with urgency.
Thank you, Ms. Addington. Ms. Ellison, was there anything else?
No, Your Honor, I think that pretty much sums it up.
Thank you. Ms. Addington, that concludes this matter, ma'am. You're free to go. You have a great day.
You too. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Heather, Sandy, and Andy, thank you for your help this morning.
You're welcome. Thank you, Judge.
You're welcome.
Andy, do you have anything else?